Hello and welcome. Thank you for tuning in to the Cook County Bar Association's Live on CAN TV. Today I will be speaking with you about Landlord-Tenant Law. My name is Mika Thompson and I am an attorney and a member of the Board of Directors for the Cook County Bar Association. If you have any questions regarding this topic, please feel free to call us at the number that appears at the bottom of your screen. 312-738-1060. I am an attorney and I am a member, as I said, of the Board of Directors for the Cook County Bar Association. This is the oldest association of African American lawyers and judges in the United States. We take this time every week at 6 p.m. to bring to you information regarding legal issues or public policy that affects the Chicagoland community and the nation at large. Some of our issues pertain to, as we did, the election, and some pertain to specific areas of law, as this show will pertain to this night. Now, although I am an attorney, and at this time I do not represent your interest, I am here specifically speaking regarding the specifics of the law in Chicago and in the state of Illinois as it pertains to landlord-tenant issues. However, if you have a legal issue and you would like to speak to an attorney, please feel free to contact the Cook County Bar's Lawyer Referral Service. The Lawyer Referral Service you can reach an assistant at the Cook County Bar Association by calling 312-630-1157, extension that's supposed to be 21, or you can go to the website on the Cook County Bar Association's website, and you can click on the lawyer referral like this, and as you can see, there's a list of attorneys that are featured there, their names, the area of law, and the phone number where they can be contacted. The quickest way is to go online and contact the lawyer that way. Before we begin our discussion about landlord-tenant law, we must inform you that the opinions and views expressed on this show do not necessarily reflect the Cook County Bar Association or its board members, its officers, or sponsors. Okay, so what I would like to discuss first is that in the city of Chicago, the alderman in the 47th Ward has proposed a change in the ordinance governing landlord-tenant law. Now, as it stands in the city of Chicago, there is an ordinance that specifically addresses issues of landlord-tenant, and it's pretty strict, and it tends to favor the tenants. One of the provisions governs the security deposit. As most people watching know, that when you rent an apartment or a house, landlords typically have in their lease agreements a provision governing the security deposits, and it spells out how much money must be turned over to the landlord for the purposes of securing the property and making sure that the landlord has sufficient funds to cover any damage done to the property. It can also cover any damage done to furniture where the lease allows for the apartment to be furnished. Under the city ordinances, that security deposit must be placed in an account that is separate from any account that the landlord uses to hold rent receipts or any of the landlord's personal assets. This account also, in some instances, may have to generate interest, and that must be returned to the tenant, the security deposit as well as the interest, once the tenant has decided to move on and live somewhere else, or the lease terminates. So that's what the law currently says. However, it has been published by the Curb City Chicago news reporting agency that the alderman for the 42nd ward in Chicago, his name is Brennan Riley. He is sponsoring a change in the ordinance requiring the ordinance, like I said, specifically states that the security deposit must be returned with interest. And there are some severe penalties. Sometimes the landlord is required to pay double what the security deposit is if the landlord fails to return the security deposit in full as it is required in the lease, where it is determined by a judge or it is evident by both parties in agreement that there was no damage to the property and that the landlord no longer has a reason to hold the security deposit. So where he fails, the landlord fails to turn over the security deposit to the tenant after the lease is over or he is prepared to move, or just a judgment has been entered by a court of competent jurisdiction that the landlord does not have basis to hold the money or has exceeded the time frame in which he had a legal authority to hold the money. The landlord under the current law will be obligated to pay penalties in addition to turning over the security deposit. Under the proposed ordinance that the 42nd Ward Alderman is submitting to the City Council, there will be a change to the law. Instead of the law as it stands, it is a requirement that the landlord shall pay the penalties. The change would allow some discretion, and the language in the change in the ordinance would then say may pay instead of shall pay. So that would give the judge the ability to exercise some discretion in a case-by-case situation and decide whether or not, in this case versus another case, the landlord should pay a penalty and how much that penalty would be. Now, of course, this is still in the proposed stages, and I'm certain that the different organizations that represent landlords as well as the organizations that represent tenants will most likely want to have some say-so about, whether or not this piece of legislation should be, whether or not this alderman's proposal should pass and that the proposed changes would come into effect. So that is something that the citizens of Chicago should be looking at and making a decision. Maybe they want to contact their alderman and voice their concerns or their objections or support for this piece of legislation. But it would clearly have an effect on landlord-tenant law here in Chicago. So that was the first thing that I wanted to talk about. The second thing is, with regards to landlord-tenant, is just the basics. So we'll go over what the the law says with regards to landlords and what the law says with regards to tenants. Now, just in general, any type of landlord-tenant relationship begins with a contract, and the contract typically is referred to a lease. In the lease, it spells out the amount of money that the apartment or house will be rented for on a monthly basis or a weekly basis. It describes the housing, whether it's a house or a apartment. It describes whether it's furnished or unfurnished, and it has to state the location of the thing. For a second, I also want to take us back to the Cook County Bar Association's website. Okay. All right, we are ready. I want to introduce our guest. That is the distinguished attorney, scoot on over some, Attorney Lewis Powell, and he is an expert in real estate law. He teaches here in Chicago at John Marshall Law School, and he is here to give some more information, more specific information regarding landlord-tenant law. So how are you doing?
You know what? I may be a so-called expert in fair housing, real estate transactions, landlord-tenant, but I think I need a helicopter because traffic was unusually heavy on Roosevelt Road. And I apologize for running late.
That's okay.
We were tied up.
That's okay. As I told the audience, there's been a proposed change in the city. I don't know if you heard about it. There's being 42nd Ward Alderman is proposing to change the city's ordinance regarding landlord-tenant as it pertains to the security deposit.
I heard.
Okay.
Now, Reader's Digest version. Under the residential landlord-tenant ordinance, you are obligated, if you take a security deposit, you're obligated as soon as practically possible to put the money in a tenant security deposit account. Ladies and gentlemen, this is critical. A tenant security deposit account is critical because the money is not yours. Actually, you're a trustee. Also, under the residential landlord-tenant ordinance, which we're going to refer to as RLTO, if you take the security deposit and you do not put it in the right account would be a tenant security account, tenant security deposit account. The ramifications are very harsh. Okay, the RLTO applies to all property 6 units and below. Actually, under 6 units, meaning a single family, which would be a house, a 2-flat, 3-flat, 4-flat, 5-flat. Okay, under the 6, if it's more than that, it's not. If it's under that, if it's more than that, it's not applicable. Okay. Also, it's not applicable if the landlord is living in the property.
Right.
Okay,
right.
so that's a key distinction.
Right.
Now, ladies and gentlemen, roughly 50% of landlords are not in compliance with the security deposit.
Yeah.
Okay? If you do not put it in the right account, automatically you are liable for 2 times the amount of the security deposit.
Wow.
And if that doesn't get your attention, this will. If you go to trial, which is absolutely crazy, where you're trying to sue somebody for rent and you have knowingly messed up on the security deposit account, the defendant's attorney is entitled to attorney fees,
Okay.
which could be astronomical. So you put yourself in a position, not only you're paying your eviction attorney, but you're paying the tenant 2 times the amount of security deposit.
And his attorney.
And his attorney. So the more that tune is, if you take a security deposit, make sure you put it in the right account. Also, under ROTO purposes, you have to put on the lease where the bank is that holds the money.
Okay.
Also, in the RTO, you have to put on the lease your contact information. It could be a property management company, but you have to put the contact information for either the property management company or your phone number, your name and phone number if you do not have a property manager. But again, you have to supply a mailing address. A P.O. box will not do. You have to supply a phone number. The phone number, again, can either be your property manager or your number. The address, again, can either be the property management office or your address, okay, your personal address or your business address. Also, you're obligated to give the tenant a summary of the RLTO. And again, when we say the RLTO, ladies and gentlemen, just make sure you're paying attention. We're talking about the residential landlord-tenant ordinance.
And that applies to residential properties located in the city of Chicago, right?
Exactly.
Okay. All right. So does this not? Because I read in the article that there also are severe penalties for failure to return the security deposit.
Absolutely. Reader's Digest version. You're obligated to return the deposit under the following conditions. One, if there's been no damage to the property.
Right.
But ladies and gentlemen, you have to pay attention. You're obligated, you hear the term 45 days. What it really means is that at the end of the 45-day time period after the tenant vacates, you're obligated to refund them if they have anything coming to them. Okay? Within 30 days, which trips up a lot of people, you're actually obligated to get on paper to tell them what, if anything, was taken from the security deposit to take care of any damages. Okay? But the key, what people really focus on, the 45-day time period, is when you have to get on paper, when you have to refund if they have anything coming. The 30-day time period, which a lot of people may forget, you're obligated to get on paper stating what, if anything, was taken from the security deposit account and putting receipts, if all possible, showing what was paid for. Routine, you can, take for stuff that is clear damages. Routine wear and tear, I'll be careful about that. Routine wear and tear, I wouldn't necessarily take that,
Deduct that from the
I
security.
wouldn't necessarily do that. Some people do it, but clearly if there's damage caused by the tenant, that is eligible to be taken from the security deposit.
What about if it's a furnished apartment? Can't you also deduct for damage to the furniture?
Anything that's damage, you can deduct for.
Okay. Now, another question that I have, there's a lot of tenants that utilize the cable services and those different I forget what they call them, that sit on the top of your roof.
Satellites.
The satellites.
Okay.
If those things cause some damage to your roof, can you deduct that from the social?
That is I know you're going that way. That's a very good question. And the reality of it is, if they do damage it, I could see a landlord going after using the security deposit as a way to take care of the damages caused by the cable installator, which happens.
Yeah, I mean, they put those things there and on top of, and many times they don't even contact the landlord. They just contract with the cable company and they go and put the satellites on top of the roof, and many times it's too close to the chimney. It can cause a lot of
and sometimes
problems.
On a routine installation, sometimes the cable installer will damage the brick and mortar.
Exactly.
Which happens a lot. So the question is, well, I'm as the landlord, I want to try to keep my outside and my exterior
That's right.
as nice as possible. You may cause me to have somebody come in and repair it.
And the wires are not always secured on the property; they're hanging over, and that can cause different injuries to other individuals that are there on site to do repairs, as well as people that are living on the property. It looks like we have a caller. Caller?
Hi.
Hi, how are you? What is your question?
I'm fine. The question is, I went to the office to get a lease, a copy of the main lease. Okay.
From your landlord?
They didn't have any. The building. It's a condo building.
Okay.
And so I know that they keep a file. So they didn't have the original lease. I went and searched everything and found mine. However, what they did give me was a lease that I had never seen before. It went all the way back to December 2015 to December 2016. And in it, and I didn't sign it because I hadn't seen it, it says, if I leave within a year, if I move within a year, I have to redecorate. Now, since I never saw this, how good is this lease without my signature?
Okay, so let me understand this. You are renting a condo unit.
I'm renting a condo.
Okay, and so this is a lease that you entered into with the condo association or the unit owner?
No, with a private owner.
Okay, so you had to go searching through who to get this?
Well, I went to the office because I know they keep a copy of your lease.
Oh, the condo association.
The condo office
keeps a copy of the lease.
They keep a copy. So I went to them, And I thought I couldn't find my original one from 7 years ago, but I ended up looking because they say they don't have any lease like that. And they did have that lease.
Okay.
I understand.
So I don't know what
I
happened to it.
understand. Okay, I understand.
But what I'm saying is that there's a lease here that I got that I did not find, that I did not see until they showed me the other day from the office.
Okay, we have about a couple of minutes, but I understand. First of all,
Okay,
how long have you lived in the unit?
7 years.
All right. Now, do you have your current lease?
Okay, I have what they call a lease extension. It's automatic renewal every year to further notice.
That's fine.
And that
Okay, hold on. It's not uncommon. A lot of times in commercial rental situations, you have what's called your master lease, and simply you extend it by a mutual agreement by amendments for a set amount of years, okay? It appears to me what you have, you signed a lease at one time, and the landlord is using amendments to continue your rental agreement, and the amendment will specify what the new rent will be, okay? So you got, okay, I think what you're saying is that you want to see what your original lease was. Is that correct?
Oh, okay, well, see, I got that. I
Mhm.
thought the office had it. They did have it.
Mm-hmm.
And they didn't have it, so when I went. But the extension says 3/2/15. The lease that I saw, didn't know anything about, says 12/9/15 to 12/31/16.
Yeah, but
Okay,
I mean,
okay,
if you
I
okay.
got it. All right, all you have to do, first of all, the basic question is, did you sign the last amendment?
The last one is what was 3/15. Yes, I did.
Okay. Is the amendment that you have matching what is in the real estate office, in the condo association office?
Right. The amendment stuff is there, but the original one is not.
The original lease?
Yes, it's not in the office.
Okay, you don't have a copy of the original lease.
I do.
Okay, you do. Okay, now
I
what is,
do.
okay, Pacific, what is your question though?
Okay, my question is, it's a lease in here that I didn't know anything about that's dated for 12/9/2015 and goes to 12/31/2016. But in it, it says, if I move within a year, I'm responsible for redecoration. How could you just add that into the lease?
You can't. And it's not, my opinion is, what you have is not effective. Because unless you sign, if what you're describing to me is an amendment, and you haven't signed the amendment, it's not in effect. If there's only one signature in it, it's not in effect, and you need to get a hold of your landlord to get it straight, not the condo association.
Right.
All they're doing, they're just the
Right.
recipient of the leases. You need to get a hold of your landlord to find out what is going on, to verify that you all on the same page. Because again, they cannot hold, the landlord cannot hold you to that amendment unless both you and the landlord signed it. Amendments happen a whole lot. Again, it happens a lot in commercial real estate where they don't redo
The
entire
entire
lease. They just simply do amendment, and it just
Right.
just continues the terms, the general terms. But what changes usually is the amount of rent that you are paying.
right. So usually, that amendment the only change is the rental.
A lot of times it's
Where's
only the actual rental amount.
So everything
Okay, so
else that remains in force. So this redecoration is more. That's a more
That's a little bit unusual.
Usual,
You need
yeah.
to contact your landlord.
right.
Okay.
Thank you.
I just happened to be flipping the channels and saw you all. I'm like, oh, I got to ask this question.
Well,
Okay,
great.
well,
We're
thank you
glad to
so. Oh, I
help.
did. I'm glad. Thank you so much for your
Well,
help.
tune in. We're here every Wednesday, so tune in. There may be another topic that would be of usefulness to you or some of your friends. So tune in. Okay. Well, thanks, Attorney White, Attorney Powell, regarding that issue, because that is unique situation, isn't it? It's not something that you normally see. So getting back to the topic and closing us out, I'm gonna leave that to you. What is your final statements that you want to give to the viewing
Know
audience?
the residential landlord-tenant ordinance. If you are a landlord, read it for yourself. And always make sure, Reader's Digest version, when you give the lease, put on there your name or the property management company. Put on the lease the phone number of the property management company if you don't have your phone number. put on the lease, if you take the security deposit, put on the lease where the security deposit is being held. Also attached to the lease a summary of the residential landlord-tenant ordinance.
Well, this concludes our topic, our discussion for today. This is the Cook County Bar Association's live on CAN TV. Please tune in next week where we will also be discussing another legal issue that is relevant to the Chicagoland community. Thank you and good night.